and a very warm welcome to Falkirk Council's Planning Committee meeting held here in the Lesser Town Hall on Wednesday the 16th of November beginning at 10 AM. In accordance with Section 43 of the Local Government in Scotland Act 2003, it has been directed that this meeting will be conducted in such a manner as to allow a remote attendance by elected members. The meeting will also be live streamed. Could I go straight away to apologies?
Thank you, Convener. We have apologies submitted by Councillor Brown.
Thank you. That takes us now to declaration of interest, and just for clarity, I'll read this out. Members should declare any financial and non-financial interest they have in any item of business at the meeting, identifying the relevant agenda item and the nature of the interest. Have we any declaration of interest at this time? No, none. Thank you very much. Takes us to item 3 on your agenda papers this morning. Minute of meeting of the Planning Committee held on the 25th of October 2022. It's pages 3 to 23 on your agenda. Any questions arising from that minute? No? Fine, thank you. Now, on the agenda this morning, we have 3 deputation requests. So just to make sure that we have a bit of continuity, we're going to change the order. And we're going to change the order where we'll go to item 7 as the first item on the agenda because it has no deputations. So item 7 is erection of dwelling house, renewal of planning permission at land to the southeast of Tappernale Farm, Hillcrest Square, Readymuir Head for Mr Philip McFarlane. It's pages 172 to 192 on your agenda papers, and the report is by Julie Seidel-Gregory. Thank you, Julie.
Thank you, Convener. Members will recall that this Planning Committee considered this application on the 16th of February this year, when it was agreed that the committee were minded to grant planning permission subject to conclusion of a legal agreement. The decision of the Planning Committee required the legal agreement to be concluded within 6 months. The legal agreement is now fully agreed and fully agreed terms and has been signed by the applicant. Unfortunately, it was not possible to conclude the legal agreement within 6 months. This was due to an initial delay by the applicant to provide their solicitor's details. It's requested that the Planning Committee agree to a short extension of 1 month from the date of this committee for the legal agreement to be concluded and to allow the decision notice to be issued thereafter. Thank you, Convener.
I'm quite happy to agree the recommendation from officers to give the continuation for the extra month. Agreed to that? Okay, thank you very much. That takes us back to the original applications contained in 4, 5 and 6. Item 4 is change of use of vacant land to form private permanent Gypsy traveller pitch, 1 static caravan and 1 tourer, formation of hard standing car parking, erection of shed retrospective at Wesley Mount Church Road, California, Falkirk for Mr Alistair Fowler. This has been continued. It's pages 24 to 44. Could I say then, before we go into the report, that we have a request here for an objector, and just getting the paperwork here. It's Mr Max Ketchen who would like to be received as a deputation. Has members agreed to hear Mr Ketchen? We're agreed to that. Fine. That's fine. Okay, then. Well, first of all, we'll go to Julie Seidel-Gregory to give us the report. Thank you, Julie.
Thank you, Convener. Members will recall that the Planning Committee considered this application on the 31st of August this year, when it was agreed to continue consideration of the application to allow officers to check the ownership position of the application site. This decision was taken following a deputation request where it was claimed that the applicant was not the owner of the application site. We've received a late objection from a Ms Robertson, who made a deputation request previously. She has raised concerns in relation to completion of the land ownership certificate, the ownership position of the application site, a request for officer investigation, inclusion of land in the application site that she believes is part of her title, flooding, access and alleged unlawful consideration of the application and previous application by the council and the reporter. The investigation in relation to land ownership is now complete. The outcome of these investigations are detailed at section number 4 of your update report. The conclusions of the investigation are that the applicant did not knowingly or recklessly issue an ownership certificate that was false or misleading. There is a full explanation of this position at section 5 to 7 of your update report, and we also have the Council's legal advisor here today to answer any questions members may have in relation to this position. The late representation mentions access to the site. Members should note that the Roads Development Unit do not object to this application and raise no concerns in relation to the continued use of this site as a Gypsy traveller pitch. The late representation also mentions flooding. The site is not in an area identified as being at risk of flooding, and a flood risk assessment is not required to support this application. This is the same position as was taken with other recent planning applications at surrounding nearby sites. A drainage impact assessment was not required, taking advice from the Council's planning advice note on flood risk and surface water drainage document. Neither flooding or drainage were identified by the reporter as a material planning consideration in relation to the appeal decision for this site. In conclusion, and noting completion of the investigation mentioned, the application is assessed as being in accordance with the development plan. This is with specific reference to policy HC09 Gypsy Traveller Sites of the Falkirk Local Development Plan 2, which permits proposals for privately owned Gypsy Traveller Sites where there is no adverse impact on the character, appearance and amenity of the area, there is reasonable access to community facilities and an appropriate level of residential amenity can be achieved. The appeal decision for planning application P16053 full is also of specific note, as discussed at sections 7B12 to 13 of your original report. No new matters are arising which would alter the recommendation to grant planning permission, and it is considered that there are no sound planning reasons to justify the refusal of planning permission in this instance. Thank you, Convener.
Thank you very much, Julie. It's now an opportunity for Mr. Ketchen. Mr. Ketchen, could you just speak just so that everybody can hear you? Could you just give us your name, sir? Can't hear you. You're mute, sir.
Is that better now, Max Ketchen?
That's fine. You've got 10 minutes, sir, and then there'll be an opportunity if members of the committee want to ask you any questions. So you have 10 minutes from now for your summaries. Thank you, sir.
Fine. I have several reasons for objecting to this planning application, but mainly the main one is, probably as has been discussed with Julie there just now, that I feel that this is a fraudulent application as well, because Mr. Fowler has declared he's the owner of the land, but he's clearly not. He is not and has never been the owner because he doesn't have a title deed from the Keeper of Registers of Scotland. And as far as I'm aware, a title deed from the Keeper is the only document which lawfully demonstrates proof of ownership of the land or property. Now, I know that I did a search of the Registers of Scotland last week, and I found that the registered owner at present is Barbara Gregors and her late husband, you know. Now, I know that Falkirk Council have also carried out a search of the registers, and they know that Mrs. Gregors and her husband are at present the legally registered owners. And I know that Mr. Henderson and Julie have stated that they have proof of ownership of this land in favour of Mr. Fowler by way of a disposition granted in 2016, and of a new disposition that was granted in 2022, just recently. Neither of these dispositions have been registered. Now, I've got copies of both of these dispositions myself, and they clearly state that the land is solely disponed, or it's disponed. The only person mentioned on the disposition is Mrs. Morag Fowler, no one else. I think as well, Mr. Henderson has gone on to say his disposition has been acknowledged in findings by Sheriff O'Mahony from the Sheriff Court, which was a result of a previous case, a civil case. I have a full judgment of this court case because it was in the public domain, and also I was a witness during the court case. So I can quote the Sheriff's finding in fact, and he said that the second and third defenders are the heritable proprietor of the property forming a plot of land measuring X point something acres conforming to the disposition. However, this is actually wrong. It's completely wrong, and it's going to be the subject of appeal. The case is actually the subject of appeal now because the Sheriff has erred. It's not the case because as I said again, the disposition, the unregistered disposition, is solely in the name of the second defender. If we go back to the sheriff, he said the second defender, who is Morag Fowler. The third defender is not mentioned. Again, I feel that planning and legal may be well of the opinion that a disposition is proof of ownership over and above a registered title deed, which I find it's not. But even if this was the case, none of the dispositions, as I've already alluded to, have given any mention of Mr. Fowler, and it's disposed solely to Mrs. Fowler. So at the current position we are is, if this disposition, which the council seem to be relying on, was to be sent to the Keeper of Scotland now, and the Keeper of Scotland decided to grant a title deed to the owner, that owner would solely be Morag Fowler. There would be no mention of Mr. Fowler on it. And the other thing I would just like to, well, the other thing is, yesterday I got an email from Micah McGuinness, from the head of planning, because I had put in a complaint, and it was a stage 2 complaint, and it appears that the opinions of the legal and planning legality of the dispositions have been formed by quotations from text by 3 professors of conveyancing. It seems very odd to me that Falkirk Council's legal and planning departments have gone to extreme lengths to determine ownership of this land, but I realise that it is a very complex case. So, indeed, at one point in my complaint, I questioned whether due diligence had been carried out on this. Mr. McGuinness quoted guidance from Collar in his book of planning, which states, in most cases, the authority will simply check that the appropriate certificates have been completed. It seems unlikely that this statutory duty extends to checking the accuracy of the notification process. Well, I would contend that this has taken due diligence to a whole new level, and I really wonder why Falkirk Council are going to so much bother. Is it possibly because they don't want to admit that they've made an error? Anyway, the other thing that I wanted to state that where are we? Right, sorry. I was just going to say the other thing, that this could have repercussions as well to the previous planning, because if it's found that this was a false declaration, then previously the Scottish Government would need to be notified, because previously they were given, Mr. and Mrs. Fowler were given the sum of £2,500 by way of expenses for taking their case to the reporter. So that would need to be looked at as well. I would also like to object to the planning application of the grounds of lack of screening on the site. This was supposed to have been put up at the end of the first planting season, when Mr. Fowler was given temporary planning permission before from the reporter in 2018. This still hasn't been done, and it never has been done. The site is in elevated position, and it's clearly visible eyesore from the north and from the road running to Shield Hill and from public paths. And I feel that given the applicant's failure to plant screening in the past, I've grave doubts that any screening would be put in place on this occasion either. I note there that Julie said that that this planning has been sought under the Gypsy / Traveller Charter. And I think that charter says that there has to be free basic services such as sewage, drainage, water have to be freely available. And this is not the case, because any services would have to go over ground that is owned by someone else. And I know that ownership, that owner would never give the agreement to this. I think Julie said at the previous meeting that Scottish Water had agreed that there was capacity in the main sewer located approximately 150 metres along the track. But I don't think she mentioned that Scottish Water also said that the connection to the main sewer would only be possible with agreement of any other landowners whose land the sewer would need to cross. This isn't going to be given. The other thing is, there's no electricity anyway along at that site. Electricity at the moment and from 2016 has been by way of a generator, either petrol or diesel, and it's quite a large generator, because I can hear it from my house and it drones on continuously day and night. And it's a nuisance, basically, more than a nuisance. Julie alluded also to the other objection that was flooding of the land to the adjacent areas, land adjacent to the site. The reason for that is hundreds of tons of unregulated building waste, and I say unregulated building waste because it hasn't been regulated. It's been dumped to form hard standing. And that leads me neatly on to my next objection, and that of excess traffic and commercial vehicles. Before 2016, this was a quiet street and there was nobody about here. The only people that ever went in and out that farm were Mr. and Mrs. Gregors themselves and an odd other car here and there. Since 2016, when Mr. and Mrs. Fowler arrived, there has been a complete explosion of vehicular traffic passing my house along the street day and night. At various times over the last 6 years, I've recorded well in excess of 30 vehicle movements in and out of that track. And in one particular day, I counted 70. Now, I'm not saying that I sit and I check these all the time, but the reason I know this is I have CCTV so I can check back on it. Most of the trailers, most of these vehicles were commercial vehicles. They were either vans or trucks or either both with maybe trailers on them. And they had construction materials or machinery or ladders or whatever, and they rattled and banged and all the rest of it. And I also witnessed the tractors and trailers and lorries that dumped the unregulated waste on that site. I was there. I saw them.
Apologies, Mr. Kitchen. Could you wind up? Your 10 minutes is up.
Okay, fine. Well, that's basically the other thing is that the continual traffic, the traffic's still continuing because people are going in and out of there to buy puppies, because I've been asked about that at the house as well. Oh, where are the puppies? Because they have kennels along there and they're selling puppies. So again, we're getting more and more traffic going in and out with things like that happening. And the final thing is the access to the site. I know it's been mentioned about roads, but it doesn't meet the National Design Roads guidelines, where access of no more than 6 houses can be taken from a duck track, because the allocation's been previously taken up by a previous planning application. That's me. Thank you very much.
No, thank you very much for your summary, sir. We'll now open it up to members of the committee. Is there any members of the committee, either here or remote, would like to ask any questions? Mr. Kitchen? No questions. I think at this stage we'll bring in Councillor Kerr. Was you a question to Mr. Kitchen?
No, for Mr. Kitchen, but
well, if you can hold on a minute, because I think it's important, because most of the summary by Mr. Kitchen was related to the legality of this, which has been a lengthy time, and I think we should pass over to our legal representative, Mr. Ian Henderson, just to give us some sort of overview, the position as we stand at the moment, and also the views that's been obtained for the summary for Mr. Kitchen. Mr. Henderson.
Thank you, Convener. And I think the report tries to set out the investigation that's taken place. And I think Mr. Kitchen raised the question about diligence in relation to checking of such matters. And I would agree that a deal of work has gone into that in this case, but that's particularly because the matter was raised at the last committee and the committee asked for a check on title position, so we looked to confirm that position as best we could, and it's also reflective of, I think Mr. Kitchen quoted a reference to Collar on planning, where it refers to it seems unlikely that the statutory duty, i.e. to check title deeds, extends to the checking of the accuracy of the notification process. It goes on to say, however, that errors in the notification process, particularly those pointed out to the planning authority prior to its decision, and that was the suggestion that was being made, that there had been an error. But it then goes on to say, but not remedied, may leave a grant of permission open to challenge in the courts by a person with a notifiable interest who received no notification of the application. So what we were wanting to do was understand as best we could the title position, and if there was a party that could potentially have been missed in terms of notification, make sure that party was appropriately notified to remedy any potential error around that. So just running through some of the points that I think Mr. Ketchum picked up and which are covered in the report. As we mentioned at the last committee, in essence, ownership of land isn't a material consideration in a planning determination. So I think the fact that the owner of land is indeed determined to prevent development taking place doesn't prevent the planning authority from taking a decision which should be on the planning merits and the public interest. However, what we noted at the last committee and is reflected in the report is that planning process is important. So I think, as Mr. Ketchen notes, there's an ownership certificate which is completed along with submission of an application, and that then triggers the appropriate notification of the parties with an ownership interest. So that's why I mentioned that we had made sure that, I think Mr. Ketchen mentioned it was Mrs. Gregors, and she has been notified of the application. I think duly notification was provided by both first class and recorded delivery post. So we have confidence that the notification was received, and at this point, no response has been received. I think it's important to run over the check that was undertaken by officers since the last meeting on the request of the committee. And that involved, as Mr. Ketchen has done, also a check with the Registers of Scotland. We made inquiries with the applicant's solicitors, and we also looked at the judgment that Mr. Ketchen referred to. And the outcome of that has been that there was a disposition granted in 2016 by Mrs. Gregors in favour of, I think you're right, Mrs. Fowler, for 0.3139 acres at Wesley Mount. That disposition hasn't been registered, and that's what the Sheriff had noted in the findings in fact, which are also referred to in the papers here. The applicant's solicitors advised that a further area of ground was purchased by the applicant's spouse in August 2018, but they advised that the disposition wasn't registered because of restrictions caused under the ongoing court action and indeed an interdict, as I believe. This year, Mrs. Gregors sold a further area of land, and there's been a wrap-up of the 3 titles that have been sold over time, and they're all covered in one disposition. I've seen a copy of that disposition, and I'm aware that it was delivered by solicitors acting by Mrs. Gregors to the Fowler's solicitors. I've already covered the Sheriff's finding in fact, and the judgment also noted affidavit evidence which was provided in the court action by Mrs. Gregors, which confirms that over a number of years she and her late husband had sold various areas of land at Wesley Mount, including to Mrs. Fowler. Now, there is obviously a position where, as Mr. Ketchen notes, that the registered title, by dint of a title not as yet having been registered by Mrs. Fowler, the registered title in Registers of Scotland does sit in the name of Mrs. Gregors, and to deal with any procedural error that may exist around the notification process, that notification has now taken place. Paragraph 6, where Mr. Ketchen notes references to the professors of conveyancing, but I think Mr. Ketchen was suggesting that in essence there is no ownership right at all unless a title has been registered in Registers of Scotland. And I suppose that's where you bring into the concept of there are layers essentially of property interest in properties. So what we have here is a situation where Mrs. Fowler is what's called an unregistered holder of land. Don't be put off by some of the terminology here, but it means that she holds a disposition but hasn't yet had that registered in the Registers of Scotland. The reason for that I'm not entirely sure of, but she has a valid conveyance from Mrs. Gregors. Now, what the Town and Country Planning Scotland Act 1997 at section 35(7), which deals with the notification of owners, does by way of a definition of owner is it refers to any person who under the Land Clauses Act, which is a reference for definitional purposes to provisions that deal with compulsory purchase and so on. So when it refers to an undertaking, it means perhaps someone like the council acquiring a title, but any person who under that legislation would be entitled to sell and convey the land to the promoters of an undertaking as the owner. And indeed, the definition goes on to note that it is also a leaseholder of a property with a lease of over 7 years. So it's not just a registered title holder. The reason I've noted in that section the references to the professors of conveyancing is that, first of all, noting what Professor Halliday comments, which is in relation to particularly the position of an unregistered title, is that once a document of transfer or conveyance, i.e. a disposition, has been signed, executed and delivered, an implement of a personal right, which perhaps in many cases is the agreeing of a contract for the sale of a property, the well-known phrase of missives, the legal position is significantly altered in a question between the parties, i.e. a personal right between the seller of that land and the recipient, the buyer of that land. When that's delivered, it transfers a right of ownership to the grantee. So it's not what we would call a real right of ownership in the sense that it's defensible against the whole world, but it's certainly defensible against the person that granted the deed. The reason that's important, the registration point, is normally so that it protects the purchaser against the risk that the person that's sold to them in breach of their contract perhaps grants a competing title to another party, or indeed that party is perhaps subject to what we would call diligence, but perhaps becomes bankrupt or something, and creditors then make a claim against the estate. And it's in that case that the person that's called the unregistered holder is exposed, because a creditor would look at the title in the registers of Scotland, or a competing party, if they beat the original grantee to the registers, would have the better right. But it doesn't mean there is no right of property. And the reason I also then quoted Professors Gretton and Reid is that it's certainly not the case that being an unregistered holder gives no rights to the person that's holding that deed. And they note indeed that such parties can grant a disposition to another third party, and if that third party registers their disposition in the registers of Scotland, they've got a real right. So in that case, when you take the definition per the Town and Country Planning Act of what an owner is, combined with the ability for someone that's not registered their title to grant a title to another party, perhaps a local authority under compulsory purchase, that party can still get the real right in the registers of Scotland. So with that all said, I think it's very difficult to conclude that there is no property interest on the part of the Fowlers. And I think it would also then be quite difficult to say that the Fowlers, and there's a knowing test in the legislation around a statutory offence and completion of the certificate. And I think it would be difficult to conclude in the knowledge of what's set out in the report that there was an intent to deceive in the ownership certificate. I think undoubtedly Mr. Fowler would have thought, I've got information from my solicitor saying that I'm the owner. I've got title deeds. I've got a sheriff saying that there's a heritable proprietorship. So I think as someone filling out that form, it would be difficult to say that he had acted with some sort of criminal intent. And then we come back to the point that setting aside that, what the council has now done is it's identified that there is a real right held by Mrs. Gregors. So what we've done is a notification of her so that she's aware of the application. She knows that it could have an impact on land in which she still has some degree of interest in. And it also meant that she could seek information from the authority or indeed submit representations, which to date she hasn't done within the timescale that I think the planning officer had notified in the letter that was sent to her. So with all that said, I think it would be difficult to say we're not now at a point where the planning merits of this application should be able to be considered, and that we have indeed remedied any potential error that may have taken place in the notification process, which affects particularly the individual that may not have initially received notification. And just to reiterate that point from the Collar textbook, the issue is not leaving a granted planning permission open to challenge in the courts by a person with a notifiable interest who received no notification of the application. And in this case, that would have been Mrs. Gregors, and she has so now been notified. So happy to answer any questions that members may have in relation to that. Thank you, Convener.
Thank you very much. First of all, I'd just like to thank yourself and officers. This has been a very complex, it's been a lengthy application. And as for members who've got to take the decision, it's difficult when you haven't got the expertise, and that's why we've got these officers beside us. I think you simplified it as best you could there, Mr. Henderson, and I'm sure that members appreciate that. So I'll go to Councillor Kerr. I think you had a question.
Mr. Henderson answered a lot of the questions there, because what I was going to say, probably no us asking Mr. Kitchen the question, but probably Ian answering some of them, but and he did that to a few things. But just on the disposition where it's Mrs. Gregor, is that right? That she's owner? No, she's owner, but she's gave a disposition to Mrs. Fowler. So how's Mr. Fowler filled the foreman then?
Thank you, Councillor. I think Mr. Fowler has perhaps conflated he and his wife in the ownership position, but I don't think that's a matter that I would consider would be a demonstration of some sort of intent to deceive. I'm also not aware, and I'm perhaps looking at the planning officer here, if there is any divergence of view of the application between Mr. and Mrs. Fowler.
Okay. I've other questions, Convener, but no on that. I'm happy with Mr. Henderson says. Okay, to carry on.
Yep, fine.
With regards to the disposition, and Mr. Henderson had mentioned that you would usually get a copy of a missive, and did we receive anything like that from the applicant or the representative?
Thank you, Councillor Kerr. I was raising the issue of missives because it's quite a common approach to the acquisition of property, but it was in demonstration of the 3 levels that go into any given conveyancing matter. It's not necessarily the case that our missives, we haven't seen copies of the missives, we've seen copies of the disposition, but when missives are entered into, they give a personal right to the buyer to purchase a property once they're concluded. The reason that I make a distinction between right and power in that case is that it's still contingent on further actions by the purchaser, and that normally is payment of a purchase price, and only once they've done that they would receive delivery of the disposition, which in terms of the quote from Professor Halliday, changes the position. So once you've received a disposition that's signed, it's competent and it's delivered, it takes you to a different position of ownership. And I would say it's almost analogous to the situation of someone buying their house, let's say from a major housing developer. So they conclude the missives, they pay the price and they get a disposition. They take possession normally the day they pay the price and get the disposition. At that point, the disposition isn't registered normally. It can take maybe a week or so for that process to go through. During the period of that week, they've got possession of the house, and it's not the case that they've got no right of ownership, which is why Professor Halliday is saying rights of ownership do pass at that point, and the position in law is substantially changed. And what that party has at that point is not a right to the property in that sense, but they've got a power to take the real right and title. In essence, all they need to do is send the deed to the registers of Scotland. They don't need anyone else's permission to register that deed. They've got it, they hold it, and they can pass it on. The next phase of ownership is the registration of the deed, which is then effective against the world as a whole. So in the step from the second point to the third point, what you've got is a personal right against the person that sold the property. So they've committed in a contract to pass on that land, and they've given you a deed which gives you that right. But what you don't have at that point is something that's made public to the world at large, i.e. in the registers of Scotland, which gives you what we would call in law a real right. And what that means is the examples I gave are the in conveyancing terms, the classic examples, that let's say the party that had originally sold the land to the purchaser, in the gap between passing a disposition on to the purchaser and that purchaser getting it registered, then incorrectly it would have to be said, because they've entered into an arrangement with the first purchaser, but let's say they granted wrongly a disposition to another party, and that party made it along to the registers before the original purchaser. As far as that goes, the second person that was granted a disposition would have the better title because they hit the registers first. And the other risk to an unregistered holder is that, as I mentioned, in the meantime, if in the gap between receiving the deed and not getting it into the registers of Scotland, let's say the original party that had conveyed the land became bankrupt, there was some sort of issue with them that creditors decided to call up their interests in property. Well, the creditors would look to the registers to say what's sitting there. Oh, indeed, there's a property, and they would gazump the party that had received the unregistered disposition. So it's you know, we're talking sort of fine points at times, but it isn't the case that there's absolutely no ownership or property rights until the deed is registered. And that's touching on the point that I raised, that when you look at the definition of owner, it doesn't actually require registration. It's just saying a party that's able to convey to another party. And that is the case, and confirmed by the professors of conveyancing, that that party that's the unregistered holder can grant a deed to a third party, and that third party can register their deed received from the unregistered holder in the registers of Scotland and get that real right against the world. So the definition of owner, per the legislation, matches the position that Mrs. Fowler's in at the moment, but we did identify that Mrs. Gregor still has that real right because she's registered, notwithstanding she's previously conveyed it. So we thought it was important just to close the loop of notification and remedy that notification process and give her an opportunity to be aware of and comment on the application. So sorry, that was a very long answer to probably quite a straightforward question, but I hope it helps to clarify things a bit.
I understood it for the first three lines, so we didn't even go on. Can I just probably cut, not for you, for Julie. So regarding, you mentioned 3 or 4 different things that when there was a previous application up there, we as a planning committee asked for these to be done, and they were never carried out. And one of the things was the flooding. You mentioned that it's no, can't remember the right word you says, but it doesn't apply to this. I used to live up there and it floods all the time into somebody else's land. Septic tank. Asked for to see if there was a registration with SEPA for the septic tank, because the septic tanks that we get nowadays, because I've put them in myself, you can actually filter the water to drink the water straight for the tank. They're that good. Have these been carried out? The drainage, I asked for a drainage the last time to see the drainage. Even drawings of or photos of the drainage, which never came forward. I think these are major things for that area. Regarding what Mr. Ketchin mentioned there, regarding being able to service the plot. If these can't be serviced because of a way leaf, how are they going to get electricity, drainage, for Scottish Water, for Scottish Power? I mentioned something else about, and I'm sure everybody else got the email last night regarding the road, the National Road Guidance. 6 roads. We had a letter, I can't remember when it was, but it was for one of our officers regarding, it was from Roddy Mackenzie. At the bottom of the thing, it says, this means that with this application being granted, a total of at least 6 residential units would be taken access off this access road. As such, this would be contrary to the NRDG, and the adoptable access road will be required. This could be used to support a recommendation of refusal. I find it strange that we've had this comment from our roads department, and I don't know if Mr. Mackenzie's still with the council or not. But I'm sure that if Julie can answer the first ones, we've got somebody for roads.
Craig Russell's here,
Craig Russell.
Councillor Kerr, we could get him in, but we'll go to Julie first then. Yeah.
All right, I'll try and go through and answer these as best I can. First of all, just to say you've referenced the previous planning application. What we're looking at is a current planning application. Roads, we can go to the roads officer in a moment, but just to highlight that roads were consulted on this current application, and they didn't raise any objections or concerns or suggest any conditions. I'm sure that Craig can come in a moment and explain that. In relation to flooding and flood risk, this application site is not in an area identified as being at flood risk. It does not come or fall within any of the situations where a flood risk assessment would be required, and that's referring back to the planning advice note on flood risk and surface water drainage for the Falkirk Council area. We do, I think we've got a flooding and drainage officer here as well that can perhaps come in a moment. The fact that we didn't ask for flood risk assessment ties in with other applications, including applications for the housing that we had up here that did not get asked for a flood risk assessment, and that was not a consideration. I'd also highlight the reporter's decision on this application where flooding was not a material planning consideration. In relation to drainage, again looking at the same advice note, which is a council's adopted advice note on flooding and drainage. A drainage impact assessment was not required. Looking at the criteria for that, it's not within a known flooding area, and it's not development with a total proposed permeable surface area that would exceed 1,000 metres squared. So I'm sure that our flooding and drainage officer can come in a second and perhaps speak to those. In terms of services, again, it would be normal during a planning application process, particularly for a development like this, where we would look to see that it would be possible to service it, but certainly we would not seek proof of that as part of the planning application process. Again, that ties into the reporter's decision notice, where there was no conditions put on requiring details of services to the site. Hopefully that answers your questions. I don't know whether it would be prudent to bring in our flooding and drainage officer that can perhaps expand on that a bit, and then maybe the roads officer.
That'd be fine. Gary McGregor first on the flooding, and then Craig Russell on the roads. Thank you.
Thanks, Julie. Basically, in answer to Councillor Kerr's queries, it's just to back up Julie's point. So, in terms of our criteria for a flood risk assessment or a drainage impact assessment, this application does not meet any of the criteria where we would ask for a flood risk assessment or a drainage impact assessment. And I can probably touch on some of them, Councillor Kerr, if you would like. So, in terms of a flood risk assessment, it's not proposed development close enough to a watercourse or a drainage ditch that poses a realistic risk. We do not have any recorded historic flooding in the area. However, I do highlight that you'd mentioned that there was flooding in the area, so that's something that we could perhaps look at moving forward. And the SEPA flood maps show a low risk of surface water. In terms of drainage, the drainage impact assessment is not required when a development with a total proposed impermeable surface area of less than 1,000 square metres or a single residential property or development within effectively a subdevelopment of a larger development area. So just to kind of back up Julie's point there, it doesn't meet any of the criteria for a flood risk assessment or a drainage impact assessment.
Thank you. We'll bring Craig Russell in on roads.
Thanks, Convener. There's been mention of the National Roads Development Guide this morning, and I think the first thing I should point out is that is a guidance document. It's not a piece of legislation or regulation. The wording of the National Roads Development Guide is that, bear with me till I get open, 6 or more individual dwellings should normally be served by a road. The word normally there suggests an element of flexibility. Indeed, the Planning Committee recently approved 6 dwelling houses off of private access just near Polmont, not long ago at all. So there are cases where more than 5 houses will be served by a private access. And referring to the current application, at the time of our site visit, there were one permanent dwelling, 1 static caravan and 1 touring caravan at the time of our site visit.
Councillor Kerr.
Back to Craig if I can, Convener.
Carry on.
So, were you aware that there is a granted plan permission for other houses in that area, Craig?
Convener, we're aware that there's a planning consent for 3 houses, I believe, in the area.
Okay. My other question, I don't know, Julie maybe never picked it up, the septic tank.
I did mention that. We talked about services, so that would be surface water drainage, fill drainage, water and electricity. So what would normally be required, as I said, as part of an application process for an application like this, they would need to show that it was possible to service it. We certainly wouldn't seek proof that there was servicing, so we wouldn't go back. To take the example of a septic tank, if you've dealt with those, you'll have experience with that. It would generally be building standards as part of a building warrant process on completion of, say, building a house, that would then look for details of that septic tank to ensure that it was large enough, for instance, to cope with the capacity of the house. It's not normally a planning issue that we will go back and put conditions on, as you'll know, dealing with this committee, asking for proof that there's connection to electricity or that there's connection to the water supply, but just that it's possible, and that's been demonstrated here.
Okay, thank you very much.
Okay, thank you. Any other questions? Councillor Bowes.
Thank you, Convener. I'd like to thank Mr Henderson for all his work he's done on this one in particular. But I'll also start with, and I think he did himself, that ownership of the land is not a material consideration on a planning application. However, I just want you to confirm to me, because I'm trying to break it down to something I can understand rather than the amount that you've covered it in. So the reason we've done that, and we've done all this work, is to ensure that there wasn't a deliberate fraud act in completion of the application, which I think you've confirmed that there hasn't been. And secondly, to make sure that the notifications for planning have gone to all people, which again in item 7 tells us, and the lady's name now is Mrs Gregor, that she has now been notified. She hasn't actually responded beyond that. So I know it was you covered it extensively, but rather than going on about the actual ownership of the land, I want to take that away. And what I'm thanking you for is the work you've done, which makes sure that we've not got a deliberate fraud, and secondly, that the full notification under planning legislation's done. I was going to talk about the service side, because I did think it would come under a building warrant more than where we are, and that will be covered by other people. I had other questions, but to be honest, James has asked a couple of them, and I'm quite satisfied with the answers that are there. I think it's important for the committee to know that going over the disposition and the deeds and all that is in the nicest way, it's not relevant to this planning application, because the ownership of that land is not actually something that we should be considering. Am I right, is what I'm asking.
Convener, with your leave, that I think essentially that is correct. What I had identified at the last committee is if there is a potential error in the notification process that has flown from an incorrect ownership certificate, that the authority ensures that it remedies that situation before taking any decision, in order to avoid a situation where the party that wasn't notified seeks to challenge the council at some later point in the courts. Thank you.
Okay. I'm conscious of the fact that we've got the Deputy Convener, Councillor Kelly, and we've got Councillor Murtagh and Councillor Colley on remote. I'm looking at you to see if you get any questions at this stage. A shake of the head there, shake of the head, shake of the head, fine. Anybody else get any other questions from Provost Bissett?
Yeah, thanks, Convener. Just on the services, I know Councillor Bow said it'll sort of be covered by a building warrant, but if we get planning consent and this goes ahead, and these services don't go ahead, what happens? Because Mr. Ketchum talked about a generator that drones on and on and on. So to have a permanent site, do you have to have a permanent supply and permanent sewage and all that as well? And if that doesn't happen, what happens then?
Thank you. That's a really good question. It's really up to the applicant to ensure that those services, you can obtain those services for the site. Just to highlight that he's been on site since 2016. As I understand it, there is a septic tank, it has mains water, and it has a generator, and that's been operating since 2016. If we did get any complaints, for instance, in relation to noise on the generator, that would be investigated by our environmental health team under statutory noise nuisance regulations. If there was an issue with the septic tank, i.e. it wasn't being emptied or it was being discharged, that could be investigated by SEPA. So in terms of planning, and to go back to the planning appeal for this one, it was not seen as a material planning consideration for the reporter, and we're also of the view that we shouldn't be seeking further information on that. It goes beyond what we would consider in terms of a planning application for this type of development.
I think we'll bring David Gray in from Environmental Services just to sort of give us an overview of what he's heard so far in relation to the areas that would affect his department. Thank you, sir.
Thank you very much, Convener. Yeah, a couple of issues there. Mr. Ketchum raised the issue of noise nuisance from the generator, and that is certainly something that we've looked at before. In 2019, before the pandemic, we had a couple of complaints actually we responded to in relation to the generator. We didn't establish nuisance, we didn't serve notice at the complaints. Kind of fizzled out a little bit on it. The last ones I can see recorded said that they also recorded that the noise was audible from the gardens but not inside the house, and was not therefore a nuisance. So we haven't managed to establish nuisance on that. The issue with the septic tank, again, I've not had any specific complaints. It would require to be registered with SEPA as law as the return officer said, and we could investigate any issues of nuisance for smell or ground contamination coming from a septic tank, but that hasn't been the case to date. The only other point I wanted to mention from Mr. Ketchum's statement, it was about puppies. There is legislation, the animal welfare licensing activities. If the site was breeding puppies, that would be a licensable activity. But again, that's not pertinent to planning. It wouldn't require a change of use or anything like that. So.
Okay, thank you very much for your input, sir. Okay, is there any other questions coming? Are members deliberating in relation to the recommendation contained, which is granting the planning permission? Councillor Kerr.
I would, after listening to various officers and members' views, I'm still not happy with the recommendation. So I would move to refuse on the grounds of I'm still no, and I might be being stupid here, I'm still not happy with the ownership thing. I think that Mr. Fowler knowingly and recklessly filled in the application. I'm not happy that the services will be granted or will be able to be serviced. If the generator's been there for 2016, why is it no put in to get the service in? I'm not happy with the flooding because it affects other areas further down. And I know Craig says that the road is a guidance. I'm not happy that the amount of traffic that will go over that road before it's made into an adoptable road.
You've heard the motion coming forward by Councillor Kerr. Have we got a seconder for that? Nope. No seconder, so. Councillor Redmond?
Yeah, I'll second that.
Okay, fine. Apologies for no recognising you there in the backdrop. Thank you, sir. Okay, well, motion moved and seconded to refuse the application on the grounds that Councillor Kerr has just stated. Is there anybody otherwise minded? Councillor Bowes.
Thank you, Convener. Given that every question that has been asked has been answered, and it's been answered very well by council officers, I would like to recommend that we grant planning permission. I know it works a strange way, so if it's an amendment to a motion, but I'm sure there's somebody better than me like that.
Okay, we have an amendment by Councillor Bowes to agree the recommendation contained within the report to grant the application. Have we got a seconder for Councillor Bowes? Councillor Sinclair?
Yeah, I'm content to second that.
Okay then. Just to clarify the position again, with a motion moved and seconded to refuse the application on the grounds it was given, and we have an amendment to agree the recommendation contained within the report. Would somebody like to come in before we go to the vote? Okay, Mr. Henderson.
Thank you, Convener. As you noted, we have a motion by Councillor Kerr, which is seconded by Councillor Redmond, to refuse the grant of planning permission on the following grounds. And please do, Councillors Kerr and Redmond, interrupt if I've not reflected this correctly. Now, the first point is an interesting one because it's related to the procedure, and in some senses the approach would be that you fail to entertain the application full stop as a result of an ownership certificate. But in any event, I've noted that you're not convinced that the ownership certificate has been correctly completed and believe that the applicant met the knowingly and recklessly test in the legislation when he was filling out the ownership certificate. You've also noted, and this is more onto the direct planning grounds, you're not satisfied that appropriate services can be provided to service the site. You also noted concern over flooding of adjoining properties that has been generated by the existing development on site. And you also noted that you consider that granting the application would be contrary to National Road Design Guidance in that there's more than 6 properties on the site that would require to be serviced by an adopted roadway. And we then have an amendment by Councillor Bowes, seconded by Councillor Sinclair, to grant permission in accordance with the officer's recommendations. So in terms of a roll call, Provost, is it?
The motion.
Councillor Bowes.
Amendment.
Councillor Brown is absent. Provost Buchanan.
I'm not the provost, by the way.
Yeah.
I'll go with the amendment.
Apologies.
Amendment.
Apologies. Thank you, and thank you for correcting me. Councillor Colley. Councillor Colley? Was that amendment?
Amendment, yes.
Councillor Forrest.
Amendment.
Councillor Kelly.
Motion.
Councillor Kerr.
Motion.
Councillor Murtagh.
Amendment.
Councillor Redmond.
Motion.
Councillor Sinclair.
Amendment.
And Councillor Steinbach.
Amendment.
We have 4 votes for the motion and 7 for the amendment. The amendment is duly carried. Thank you, convener.
Okay, thank you very much for that. It was a long deliberation. It's been running longer than Coronation Street, that application. Now the decision's been taken. Okay, thank you, members. Okay, we're deciding we're having a comfort break at this stage for 10 minutes. Thank you, everybody. No, we're still waiting on Ian. Just waiting on Mr. Dryden. Is that ready to go, Jack?
Yeah, Councillor Redmond's left the meeting.
Okay. Okay then, thank you very much everybody. We'll reconvene the meeting and we're heading to item 5 on your agenda. Today it's construction of 229 dwelling houses with associated access, parking, landscaping, open space and drainage. Phase 1 subject to detailed approval. Plan permission in principle is also sought for further residential development with potential commercial community use. Phase 2 associated access, parking, landscaping, open space and drainage at the land of the south of Bowness Fire Station, Caulfield Road, Bowness for Robertson Residential Group, AWG Property Limited, McTaggart Mickle Homes Limited, and the partners of the trustees for the firm for Messrs Robert Pow. Continuation, it's pages 45 to 96. Now, an application had been made by Colin Lavity, agent for the applicant, to be received as a deputation to be heard in respect of this item of business. Before we carry on, everybody quite happy to hear the agent? Agreed to that? Thank you very much. The planning officer this morning is Kevin Brown, and we'll go straight to Kevin because I think Kevin's got an update on this application. Kevin.
Thank you, convener. Yes, I wonder if Jack could potentially share the master plan which should be in the folder there. If committee could see that, it's just to give the committee some context to this application. It's relatively unusual in that it's a hybrid application proposing to development on allocated housing site H55 on the southern side of Caulfield Road in Bowness. As you can see there, half of the site is actually proposed as a detailed application and half of the site in a seeking planning permission in principle for housing development. The detailed portion proposes 229 dwelling houses on the eastern half of the site, referred to as phase 1, with the remainder of the site, the western portion, referred to as phase 2. The proposals include new vehicular accesses onto Caulfield Road, provision of new play area to the southern edge of the phase 1, a new kickabout area in the northwest corner of that phase as well, and the formation of new drainage ponds along the Caulfield Road frontage. During the course of the application, we've received 4 letters of objection and 2 letters of support received from individuals, with the points raised being summarised in the report. Members should note that one of these representations relates to representation submitted on behalf of the Friends of Kinneil. This representation making a case for developer contributions from this site to be spent within the Kinneil estate. In terms of the consultation process, responses to consultation are summarised within this report, and members will note that a number of consultations have prompted requests for developer contributions, a breakdown of which is included within the officer recommendation. Members will note that contributions include £100 per dwelling house towards public art and £250 per dwelling house towards green space improvements. Following completion of open space audits, envisaged that the most appropriate location for these particular contributions to be spent would be within the Kinneil estate itself, which lies to the northwest of the site. In terms of officer recommendation, we have this morning received further late communication from our flooding team in respect of potential further flooding and drainage issues that need to be further investigated. In light of that, officer recommendation at this time would be to continue the application to allow some more information to be exchanged, so that we can bottom out any potential issue that is there. There has been extensive information passed back and forth between the council's flooding team. We've been in contact with SEPA and with the applicants, but this is something which has cropped up as of this morning, so we've not had an opportunity to address that in the report. So our recommendation at this time would be for members to allow continuation of the item for us to come back at a future meeting for a further update.
Thank you, Kevin. I think flooding is a major issue, and until we get the proper information, I would happily support the officer's recommendation for a continuation at this stage. Councillor Sinclair.
Can I don't disagree with you, convener, but can I just ask if there's any potential risk in terms of timing, the timeline for the planning application?
Kevin, I'll come back to you on that question.
Yes, ultimately there is. The applicant would be open to appeal the application against non-determination if they wished. I think the issue which has been raised is something which we would hopefully be able to address relatively swiftly, and we would hopefully be able to bring the application back to the next planning committee in the new year. Obviously, so it would be up to the applicant as to whether or not that timescale was suitable to them in respect of their own aspirations for the site.
Okay.
Thanks, convener. No further question.
Okay then.
I'm quite happy to go with your recommendation, convener. But if the information's done before the next plan, would there be an opportunity? Because
I know
an opportunity to have a special meeting.
Yes.
To convene for this.
Well, we've done it in the past, and I'm quite sure that it would be, because we haven't got another planning meeting until I think it's January. So if this information was gathered, then I'm quite sure that we could have a special meeting to ensure that this is done as speedily as possible.
Yeah, fund's important.
It is indeed. Okay. Right. Okay. Councillor Murtagh.
Yeah, I don't disagree with what your recommendation is or what your proposal is. I just wonder whether there's a possibility, given that we have the deputation request here and given the question that Councillor Sinclair asked, whether it wouldn't be prudent to hear. I don't know what obviously the applicant wanted to say to the committee this morning, but in some ways I think it might be useful in this context to hear if there is something, given that I think we're probably minded to continue that Mr. Lavetti would like to contribute. I'd be kind of happy to hear that, maybe not a full deputation, but just in brief, given the situation of continuation. Just a question really about how committee, whether we could do that and how others would feel about it.
That's a valid point, and if members were agreed, we could go to Mr. Lavetti and just, obviously, Mr. Lavetti, we've just had this information for the planning officer in relation to the recommendations now for the officers to continue. It might be a bit difficult for you to give a full summary because we're not taking any decision this morning, but if you would just like maybe just to come in and give us an overview and maybe touch on the factors that this has been held up because of this issue. So we'll bring you in at this stage, Mr. Lavetti. Thank you.
Yeah, thanks very much. Hopefully you can hear me. Yeah, I think having just listened to what's went on, we kind of expected if there is going to be a further committee to deliver a full deputation kind of on that date. As you've heard earlier, we've only became aware of this information this morning as well, which is obviously disappointing for us because we were aware, based on the terms of the revised committee report in front of you, that these matters had all been resolved, and clearly members will remember that we also sat through the last planning committee and were continued for similar reasons. So we appreciate that members need to have, or the case officer needs to provide a full report, and members need to have all the information provided. But, you know, I've got a full 5-minute deputation here, which was hopefully going to summarise, you know, this is an allocated site, it's a priority for development, that we've addressed every technical issue available, you know, up until this morning, that there was no objections from any consultees and a low number of objections from the local community, and obviously some letters of support. So that picture's maybe slightly different now. However, I don't know whether there's, if Kevin feels there's merit in us going through any more detail, or we hold the rest of the summary back until the next committee. But yeah, as far as we're concerned, the application is absolutely ready to go forward, hopefully for approval. We've worked really hard and really closely with Kevin Brown and the team since the application was submitted in February this year to try and get to this point. So yeah, disappointing for us that it has to be continued, but we will obviously provide whatever information is still required. And as Kevin said, I think we're also confident that we can provide that information, whatever's required, swiftly, and try and come forward if there was an opportunity to do a special committee pre the Christmas break. That would be very much something we would want to happen, because I'm also a representative. I'm the planning consultant for the applicant, but having to continue into January is not ideal from them for a host of reasons. So we'd be very keen to try and resolve the issues once we understand what they are, and go from there. So, as I say, there is very much a more detailed summary maybe to give you at the next committee once Kevin will obviously do a full, I think, summary of the application at that point.
Okay, thank you. We do appreciate a position. You'll appreciate our position as well as committee members, that this information just came forward this morning, and obviously before we can take a decision, we've got to be aware of all the full facts, which includes a full summary for your good self. Councillor Bowes.
I don't disagree with the continuation. My only question is, and I'm trying to find a potential way forward. Is it possible to hear this, to make a decision? And I'm not saying it will, but if it was to go in a positive, is to put it as a condition on the flood report. It might not be, but just a thought.
We'll bring Mr. Dryden in. I see where you're coming from there.
No, thank you, Convener, and Councillor Bowes, you make a very good point. I think I would probably advise, given the nature of the outstanding issue that has transpired this morning, that involves potentially a statutory consultee, it would be better to try and resolve this matter now before we bring it back to yourselves. And I think really it would be better to leave that off the table just now, and we come back with an update report. And clearly, in light of what's happened, because it's late this morning, we will endeavour to try and expedite this and bring it back, and rather actually not determine the application in the absence of clarity on what is an important fundamental issue. Thank you.
No, it's a valid point. We're all the same. We just want to get conduct the business. Okay, then we've got a Councillor Murtagh again. Thank you.
No, I was pretty much going to ask the question that Councillor Bowes had asked, and I think I'm slightly concerned about, I take of Mr. Dryden saying if it really feels that it needs to have that statutory consultee, and it couldn't be caveated to respond or dealt with under planning condition if we were minded to grant, which obviously we need to hear the details. But I would like to, if in the continuation, if you don't mind, Convener, that we make it explicitly clear that every effort to try to bring this back in a special meeting or in a way, because I think we've all been there in the past where if this happens and it goes to appeal, it actually takes longer for everybody, and including us, and we have to hear it and whatever, and it is really it's not good for anybody, whether it's the applicant or the committee or the people in the community. So if we could include that within the kind of continuation motion, just to make it really clear, it's important.
Okay, I think we'll echo your sentiments. Okay, anybody else like to come in? Mr. Lavetti, you want to come back in?
Yes, if that's possible. Thank you, Chair. It was more just to say, from our point of view, I think we would tend to agree with the suggestion made about allowing the application to proceed and consider a condition. Our understanding was that the late representation was from the council's own internal flood risk team and not from an external statutory consultee. So, and given the comments made about we think this can be swiftly resolved, our view is that the the planning authority and the members have the full ability to apply a condition to the application now if they were minded to approve it. But I do respect your officer's view on that. That's just my opinion on behalf of the applicants.
Thank you, and you're entitled to your opinion. I'll come back to Mr. Dryden on that issue. We'll go to clarify this.
Yeah, thank you, Mr. Levitt. He's quite right. I can understand from his side. I think clearly because it's just very late on this morning that we received, it just may involve potential implications to involve the statutory consultee again. So with that area where we are just now, we need to get further clarification on that, which I've asked officers to expedite. As a result of that, so I think, well, I know your comments, and certainly if I was in your position, I could understand that. I think until we know what the implications are, it would be better not to take a determination on the application this morning. And I think certainly if it potentially means that we have to maybe seek further clarity from a statutory consultee such as SEPA, it'd be better to get this clarified and before we actually bring it back. Thank you.
Okay, Mr. Dryden, I'll tell you just now, Mr. Levitt, that members of this committee will try and ensure that this application comes up before we break up at Christmas time. Okay, then we've got a recommendation for officers to continue. You've heard the short debate. Has everybody agreed to the continuation and the hope that we can bring this to committee before Christmas? Agreed to that. Thank you very much.
Yeah.
Okay, thank you very much. This takes us to item 6, which is erection of visitor centre to include information, exhibition space, arts and crafts workshop, restrooms, cafe and retail area, and 82 bungalows at Earth Mains Farm, Cemetery Road, Ayr, for George Russell Construction Limited. The report is by Brent Vivian and it's pages 97 to 101. Now, before we go on, there's an application has been made by Mr. David Jones, agent for the applicant, to be received as a deputation to be heard in respect of this item of business. We agreed, first of all, to hear Mr. Jones. Thank you. And I believe that Mr. Jones wants to talk to the committee initially in relation to the possibility of a continuation here. Can I bring you in at this stage, Mr. Jones, before we go to Mr. Vivian, just see if you can just give us an update on this issue?
Thank you, Convener. Can you hear me? Yes, Convener, can you hear me? If that's, I'm grateful for this opportunity to speak to the committee. The application itself is quite extensive, and there are a number of factors which we're still working on before we would like to have an opportunity to give our presentation to the committee. Not least the implications relative to discrimination and the fact that if we choose to follow the advice in part of the committee report, we may be prepared to accept, if you like, a no age group restriction, but the impact on that in terms of the financing for the development is something which we need to work through. So on those two issues, we still have some further investigation to be completed before we can come back to you and make a full deputation. Okay, thanks for that. Once again, I'm in members' hands because this information just came forward there early this morning. Councillor Kerr.
Just to ask the agent, same as the last time, how long would it take, and if so, could that be in the same meeting as the previous one?
Okay, Mr. Jones, you've heard the question. How long before you believe that you have the summary ready for a committee to make a decision on? You're on mute, Mr. Jones. Mr. Jones, you're on mute.
Yes, thank you, Convener. Yes, I'm confident at this point in time that we will have a full summary for your next available committee. If it's before Christmas, we will work to that timetable.
Yeah, I'm going to repeat Councillor Sinclair's question and I'm not saying that this is a deliberate or anything, I'm just saying is, do we put ourselves in a position of non-determination, or are we within time on that?
just ask Mr Vivian just to check in terms of the time period for extension to the determination of the application that's agreed. Brent, could you advise where we stand with the current agreement we have for the determination date?
Yeah, the last agreement was up until a point quite some time ago. I think it was February. So my understanding, the agent will correct me if I'm wrong, is that we're now beyond the point where the applicant could appeal non-determination.
Yeah, if that's the case, obviously Mr Jones is on the call, but my understanding what Brent's saying is that the time period for the agreement has now lapsed, and normally there's a 3-month period with which the applicant can appeal non-determination, and that period has now lapsed, so there's no scope or no scenario of an appeal against non-determination coming forward. Thank you.
That was a good question again, Councillor Bowes, following on for Councillor Murtaugh's questions originally. Councillor Murtaugh?
Thanks, Provost. I suppose like it's a very extensive report, and obviously we have a lot of familiarity with having gone through 2 predetermination hearings about the variety of different things to be considered here. I think that having looking through it, that the aspect about the legality over the equalities aspect is only one part of many reasons to be considered in this application, and I'm just concerned that what's being said by the applicant or the applicant's agent here is that they need to go away and work out different things on the finances. And from reading the report, even from memory of what's in there, some of the financial things of saying, well, if you take that out, what the professional advice would have been, I think, to kind of that we'd need to double the number of houses, etc. And whether that would be what the proposal would come back with, which would severely doubt that would seem that the application would have to be significantly altered, and rather than a new, like, does certain things in it. I wonder if planning officers could advise if that kind of thing is going to be a new application in effect, rather than kind of just changing the terms of this one or conditioning over this one, because I'm not sure that I think that there's enough today to determine it one way or another, and that we've had a long time to look at this and to consider these points, and these arguments are not new about this, and I would prefer to go forward and consider it today, but I'd like to know what officers think in terms of whether it would, the kind of changes would need a full application really, if they're going to change the situation about units or finances, etc.
Convener Falcom, your Councillor Murtaugh's raised a valid point. Again, I think it's really, obviously you've heard what the agent has asked for. I think depending on what comes forward, should committee allow that continuation, it'll be for officers then to determine actually what comes forward in response to obviously what's been raised by Mr Jones. We will decide obviously the materiality of change. Obviously if there's anything new, but actually if you've already got a certain agreed level and it's actually ratcheting back, then it may well be that it can be taken within the kind of the encompass the current application. So really, until we see what comes forward, it will be difficult for us to at this point in time make that view for you this morning on whether it's a material change or not. But I think the point you've raised is valid, and it's really for yourselves as committee to decide whether you wish to hear the application as it stands just now, despite what Mr Jones has said, or if you wish a continuation. That's something then we can look at, and obviously we will await for the further information, then take a decision on whether there's any change to the material nature of that. And then clearly with that in mind, and like what you've already heard this morning, we're seeking to try and find an alternative date. Clearly we'll endeavour to try and meet that if that's what you wish, but obviously we'll have to wait really to see what comes in from the applicant agent to determine that.
Okay, thank you for your response there, and I can sympathise with everybody on this one, because this has been long-standing, this one. And it's not that just the fault of the applicant. The fact is that we've taken considerable time to actually conclude this, because first of all, we had a predetermination hearing, as Councillor Murtaugh says, initially on this, and then we hadn't enough information to take a decision. We run out of time, and it was the election. We've now been in a position where we've had another predetermination hearing. We're still not apparently ready to conclude. So the very fact that it's been ongoing, it's nobody's fault, it's just the way circumstances are, then I don't see a problem in allowing them an extra few weeks, because what Councillor Kerr says, would it be possible to have these two applications ready for a special meeting before Christmas? I think if members agree, because we haven't agreed to anything on this one yet, if that was the case, then I'm quite sure that as a convener, and I'm quite sure my deputy convener and members of the committee would try our utmost, along with officers, to try and ensure that for the benefit everybody, including the communities and the applicants, that we can get a final decision on these two applications before we break up for Christmas. So that's my interpretation of it. Councillor Probisby.
Yeah, thanks very much, Convener. I would wholeheartedly agree just with what you've said there, in light of what the agent said, and I would formally move a continuation.
Okay, I'm quite happy to second. Is there anybody otherwise minded? No.
I would rather we heard it today,
Right.
but if I'm not going to move an amendment unless there's significant feeling in the room. I take what's being said, but I think that the issues in the report and the recommendations are so significant that it would be better to hear it today. But if the committee are wanting to continue, then that's fine. I would note my objection to that.
Okay, thank you very much for that. It's frustrating for everybody, because I was hoping that this application would have been sorted out before and another application, because if you remember, Gilson was held up as well in relation to the fact is that after going out on a site visit that we didn't take a decision, and then the next thing was we were in the throes of an election. So we want to finalise that for everybody's sake, and we'd just like to agree the continuation, and hopefully that the two applicants are in constant touch with our officers to ensure that they've got enough information to bring forward that special meeting. Councillor Bowie.
Thank you, Convener. I get Councillor Murtaugh's point about this. However, I also take and listen to Mr Dryden as well, and I think that's probably the important one is always go to our officers, and Mr Dryden's telling us that he doesn't know the nature of it, and it might be significant, it might not be, but if it was significant, we could end up making a decision, and then there's something significant comes in. So I do agree that I would have probably liked to go on with this today, but I think a continuation is what we probably have to do.
Okay, it's agreed continuation. Okay, and thank you very much once again for your invaluable support at this committee, and thanks to those remote, including the deputy convener there, Councillor Murtaugh and Councillor Colley and Councillor Redmond. Thank you. Okay.